I'm Chloé Marnet-Bassanger, and I'm the team leader for the UN team of experts on rule of law and sexual violence in conflict, and it's my pleasure to be moderating this panel today. About a year ago, the UN team of experts decided to collaborate with the Journal of International Criminal Justice on a special issue to commemorate 10 years since the operationalization of the UN team of experts by the UN Security Council. During that time, we have witnessed progress in national accountability efforts to address sexual violence in conflict, but we've also encountered many challenges. The focus of the digital dialogue series, which this webinar is inaugurating today, is to explore the themes of the special issue and delve further into those issues in order to push the agenda forward and consider possible ways to advance accountability at the national levels in the coming years. I'm joined today in this dialogue by many champions and experts. And to kick us off, I would like to give the floor to a very special first panelist, Ms. Pramila Patten. Ms. Pramila Patten is the Undersecretary General and Special Representative of the Secretary General on sexual violence in conflict. You're a former practicing lawyer yourself, and you've been fighting for these issues for years in your various capacity, Pramila. Pramila, could you give us your views on the trajectory of accountability for conflict-related sexual violence, and perhaps how the team of experts has been involved in addressing impunity over the past 10 years? Pramila, over to you.
Thank you, Chloe. Before I answer your very interesting question, I would like to first and foremost extend my personal thanks to the Journal of International Criminal Justice for collaborating with my mandate and the team of experts on the rule of law and sexual violence in conflict in producing this special issue, as well as to the Washington University in St. Louis for hosting this first webinar in the Digital Dialogue series. I am also very grateful to my fellow panelists, especially my dear friend and predecessor, Margaret Wallstrom, for participating, and to, of course, everyone who joined us today. The United Nations Security Council has established that the use of conflict-related sexual violence threatens international peace and security. Most importantly for today's discussion, the Council recalled that ending impunity for these crimes is a responsibility for every state. A decade ago, the Security Council created the post of the Special Representative of the Secretary General on sexual violence in conflict in order to provide coherent global and strategic leadership to address CRSV. When I assumed this post in June 2017, I stated that my main strategic priorities include turning cultures of impunity into cultures of deterrence and prevention, as well as the importance of having a survivor-centered approach, as for me, this mandate has the face of a survivor. If we are to provide a holistic survivor-centered approach to addressing CRSV, we must ensure justice for all survivors. The justice processes we construct must also tackle intersecting inequalities and root causes to ensure that no one is excluded from these processes. One of my main roles as special representative is to negotiate agreements on behalf of the UN system with member states, regional organizations, and parties to conflict on upholding their obligations under both the Security Council resolutions on CRSV and international law. Each agreement that I have negotiated, whether in the form of a joint communique or a framework of cooperation, has placed holistic survivor-centered justice at its heart. Not only is that my duty as special representative, but it is also a profoundly personal one. My previous work as a lawyer, an independent expert for the CEDAW Committee and other UN mechanisms, and as a civil society activist, all reinforced to me the need for governments to fulfill their obligations to provide justice to the survivors. And what does this concretely mean in practice? It means fostering national ownership to ensure national legislation to meet international norms and standards, enhancing the political will and technical capacity for governments to carry out their investigations and prosecutions of perpetrators with due process of law, securing the protection and support of victims and witnesses, and guaranteeing that survivors have services they need, as well as restitution and reparation for the sexual violence they suffered. Importantly, it also means listening to the voices of survivors and civil society organizations to understand what justice means for them and respond to their needs. One of the tools at my and every member state disposal was also created by the Security Council over a decade ago, and it is the team of experts. The team of experts' mandate is to assist states in strengthening their justice institutions so that they may fill their obligations under international law to end impunity for CRSV. And the team does this through the provision of targeted technical expertise and material assistance to national authorities in collaboration with its UN partners on the ground and civil society. The team of experts has engaged heavily at the field level to provide this support in conflict, post-conflict, and fragile situations globally. And we do count some important successes. For example, in the Democratic Republic of the Congo, the team worked with the country team on prioritizing the gravest cases of CRSV for action by the government. And this prioritization strategy has resulted in the prosecution of several emblematic cases. For example, there was a conviction in the Kavumu case that you will hear more about by the panelists, as well as the trial of the infamous Thabo Taberi Sheka, who stands accused of one of the worst mass rapes of the past decade in the country, with over 300 victims. And I must say that accountability is progressing well in the DRC. We also have the case of the massacre in Guinea-Conakry. And the team deployed an expert immediately after the report of the International Commission of Inquiry. The team deployed an expert to work closely with partners to advance the trials for the massacre and mass rape around the Conakry Stadium of 28th of September 2009. And in 2017, 15 indictments by Guinea's investigative panel of judges were issued, including against the former head of state. Appeals were also rejected on these indictments in 2019, and a government steering committee has been established to take these cases forward to trial. Unfortunately, the trials have not yet taken place, and it will require genuine political leadership and material support to have these trials proceed. In Central African Republic, the team has deployed an expert to work with national authorities to set up a specialized police unit to respond to sexual and gender-based violence crimes. And this expert is also working with the Central African Republic's judiciary, both national and special criminal court, to ensure that sexual violence cases are heard promptly. Our work must, however, not remain static. As the manifestations of sexual violence vary in different conflict settings, often becoming more brutal than ever, we must adapt to address new trends. In that context, for example, understanding and addressing sexual violence committed by terrorist groups such as Daesh and Boko Haram has been another priority for me. The team of experts continues to engage with the government of Iraq, victims and civil society groups who all acknowledge the need to bring trials against perpetrators of sexual violence, not only as terrorism, but as sexual violence offenses under Iraq's national law. In Iraq, as in Nigeria and in many other countries where sexual violence has been increasingly used as a tactic of terrorism, the team of experts continues to engage with national authorities, but the challenge to bring these perpetrators to justice, charged specifically for sexual violence, remains a challenge for all of us. And as a community, we need to reflect on how we ensure sexual violence victims of terrorism are fully recognized. Justice for conflict-related sexual violence remains, impunity remains the rule, and justice remains elusive. But as you will hear today and during the series, there is growing evidence that demonstrates that at national level, whenever there is political will and capacity, impunity for sexual violence can be addressed. And for success to continue, this requires renewed and continued investment in this agenda. And this is particularly important at a time when COVID-19 may divert attention despite increasing needs generated by the pandemic. The team of experts and the journal produced a special issue with authors from a variety of backgrounds and disciplines to show that progress can and has occurred, but also that challenges remain. I believe the articles contained within this special issue are set to become a major contribution to the literature. I am excited to listen and dialogue with all the panelists on their essential work in this field. And again, many thanks to all of you.
Thank you very much, Pramila, for giving us this helpful background and spark our thinking in this dialogue. It's always important to ground our conversations in an understanding of how things have developed in the past, to really think about where we as practitioners or scholars or policymakers need to go in the future to make impunity a thing of the past. I'd like to now turn to our next panelist, Guido Acquaviva. Guido, you are a member of the editorial board of the Journal of International Criminal Justice. Now, Guido, could you tell us, out of all of the issues, out of all of the hot topics that the journal could have focused on, why did you decide to support a special issue on national accountability efforts to address conflict-related sexual violence?
Thank you. Thank you very much. Good morning, good afternoon, and good evening to everyone, depending on where each one of you is. It's an honor to be here with you to celebrate the launch of this special issue during this momentous event. It was an honor to collaborate with the team of experts. As you know, the journal is a major academic publication dealing with international criminal justice. It addresses this issue from the angles of law, but also sociology, criminology, philosophy, history. From its launch back in 2004 and 2005, it has hosted papers on conflict-related sexual violence, among many other subjects, of course. The special issues, this one in particular, features 14 substantive papers. I should really say that several more papers we received were interesting and worthy of publication. We received about 90 proposals. Of these, 2 dozens were invited to submit to double-blind peer reviewers, and about half of those were finally published after the whole process. I want to thank here all of the authors who submitted abstracts and papers. Many of them were interesting and worthy of being pursued, but the journal and the team of experts were unable to publish them all. As you asked, Chloe, why is this special issue important for the journal and the broader audience? The journal has, from its inception, encouraged bold reflections on criminal justice. We do not deal with international law only, but justice in general. This means maintaining a broader perspective. In the CSRV context especially, this often requires going beyond the landmarks we have grown accustomed to as international lawyers. Yes, of course, the ICTR Akayesu judgment was a pivotal moment in several of these areas. We all know this, but this was over 20 years ago. Much has happened in the legal and judicial landscape, both international and above all domestic. And we should take stock of this, build on what happens around the world as notions and experiences evolve. The special issues focuses in particular on domestic experiences, ranging from Colombia to South Sudan, to the Central African Republic, to Bosnia, and many others. And on cross-cutting topics such as slave trade and the psychological models to support effective prosecutions in these cases. Indeed, if we don't want to present an unsophisticated account of CRSV and of its consequences, we feel that we need a variety of voices with a global, inclusive, and multidisciplinary approach. Law, of course, but also sociology, anthropology, psychology, and many more. questions of compliance always intertwine with other fields. Learning from domestic experiences and heeding to diverse voices is actually a prerequisite if we want to achieve compliance, which follows from a commitment to respect the law, but of course goes well beyond the commitment, as the SRSG aptly reminds us often. In this special issue, expert voices have actually come from all over the world to engage in exchanges of best practices and reflections on the path walked thus far and on the road still to be walked. It is not just a matter of laws of war or the appropriate definition of genocide. The discourse must broaden to encompass psychological, cultural, evidentiary issues and must continue with a focus on national legal system. This is also what in ICC parlance is termed complementarity. The domestic systems are the first line of defense to achieve compliance. International actors are to support, intervene only when national systems are unwilling or unable. The work of the team of experts demonstrates that what can be done when partnership with domestic actors is triggered and followed up. Allow me a final remark. Several of the papers in these special issues were co-authored. We have a total, I think, of 26 authors, but only a handful of men submitted papers and original reflections. In the steps to be taken in the discourse that needs to continue, I personally believe that we need a broad input in terms of gender, cultural, and legal background and perspectives. The Journal of International Criminal Justice certainly encourages this. Thank you very much.
Thank you, Guido, for this. I think now, by hearing you, all of our followers will run and download the special issue. The special issue is available for free until 31st of July on the Journal of International Criminal Justice website, and we really encourage everyone to make use of that opportunity and that landmark publication. Guido, thanks so much. We really enjoyed working with you and the journal colleagues on the special issue. And as you say, this really comes at a moment where we all need to be reminded of some of our successes so that we can find the energy to actually move forward and fight further for accountability on that important issue. We have with us today some of the contributors of this special issue. Kim Zelinger, Karen Neymar, Daniele Perisi, thank you again all for joining us. Kim, you're an associate professor and director of the Center for Human Rights, Gender and Migration at Washington University in St. Louis School of Law. And you're also one of the leading experts on sexual violence related to armed conflict. I wanted to start the dialogue and delving into our issue with you because your article in the special issue gives a very good overview of the landscape of national accountability efforts and also some of the history behind those efforts and how they tie in and build on and complement the international efforts and go beyond the landmarks, as Guido just mentioned. So, Kim, drawing on the points that you made in your article, I'd like to ask if you were asked by a member state or an international organization about the benefits, but also the challenges of pursuing domestic accountability for sexual violence in conflict, what would you tell them?
Thanks, Chloe. I'd be happy to think through this with you. I think what's so interesting is that national courts have been an important player in the prosecution of international crimes, including those involving sexual violence, for a very long time. For many, many centuries, military courts were the ones that handled cases of wartime crimes, including sometimes those involving sexual violence. A lot of us like to think back to 1474, for example, when Sir Peter von Hagenbach was tried for the rape his soldiers committed. But also I'm thinking more recently to the 1940s, when the UN War Crimes Commission worked right after World War II to help dozens of domestic courts around the world prosecute former Axis soldiers for wartime atrocities, sometimes including sexual violence. Today, we see a great diversification of national mechanisms. We still have military courts, of course, but we also have in situ hybrid courts that sit in national systems, although they have some internationalized aspects to them, perhaps in terms of judges on the bench, or the degree to which they meld substantive provisions regarding international crimes with domestic criminal procedure. Finally, we have quote unquote purely domestic war crimes or international crimes chambers. I'm thinking of Uganda's International Crimes Division, or the Bosnia-Herzegovina War Crimes Chamber, or the High Risk Court in Guatemala. This diversification is heartening, and it's also very important because it means that there are now many routes to accountability at the national level. And this means we can reach different actors in different venues at different times. So for example, military tribunals often address sexual violence contemporaneously and can hold lower level soldiers to account in a way that distant international tribunals can't as easily. On the other hand, hybrid tribunals or specialized chambers may take a while to be developed, and they can come along years after, but they may be better able to conduct investigations and a full gender analysis after the chaos of conflict has settled, and once more witnesses and survivors feel confident and secure coming forward. So having these various institutions sewn into different parts of a domestic system can help create a normative shift towards accepting a state's obligation to investigate and prosecute international crimes, including those involving sexual violence. In terms of other benefits to pursuing justice in these national courts, there are many. I suppose it first depends on how you measure justice. We could look at traditional technical metrics like convictions. Do we have them? Yes, national courts have been delivering many convictions for conflict-related sexual violence. I'm thinking about the trial of Hissène Habré in Senegal for atrocities committed while he was president of Chad. We'll hear later today and in the coming months about the Kavumu case in Eastern DRC, and also the inspiring Sepu Zarco trial in Guatemala. There are benefits to survivors and the community directly, right, when we bring justice efforts closer to home. For example, we know that proper investigation of atrocity crimes takes both proximity and contextual knowledge, which can be difficult to develop continents away. And this is particularly true in cases of conflict-related sexual violence, which require a deep understanding of local gender norms, as well as close relationships with strong intermediaries and service providers to ensure support and protection for the survivors we engage in legal processes. Second, national courts can help a local population learn about the justice system, especially where we have innovations like mobile courts that are used to disseminate the judicial activities into more rural areas. And this can be accompanied by strengthened perception or understanding of justice. It makes me think of Patrick Vink and Phong Pham's work when we were all back at Berkeley together. Whether it be in Uganda or Cambodia, data indicate that the conduct of trials in country can improve people's understanding or even trust in their own legal systems. We also have transformative measures, right? Transformative benefits. Institutionally, we see that many states are building their expertise and competence in establishing war crimes chambers and also specialized investigation and prosecution units that train actors on international crimes specifically. I've watched up close where many countries have done this for the very first time. And I admit their first investigations or prosecutions are never perfect, but they are still important as a starting point and as an expression of state commitment. In terms of transitional justice, local courts can be more responsive and integrated in an overall transitional justice effort. Truth and Reconciliation Commissions or Commissions of Inquiry, for example, might request the establishment of local tribunals to try crimes they've documented. And in this way, the establishment of national chambers not only helps fulfill the promise to deal with conflict-era crimes, but it creates a space to address future crimes as well. And this institutionalizes the transitional justice value of accountability. But listen, we should not be overly romantic about it, of course. While they've shown tremendous promise, national courts also struggle with profound challenges in their pursuit of justice, including for conflict-related sexual violence. We have problems with legal frameworks. Sometimes the offenses or the definitions of those offenses in the domestic law may differ from how crimes are understood in international law. And so this creates an interpretation and a prioritization issue sometimes. Or perhaps we have the death penalty on the books in a country. I'm thinking of Iraq, for example, and so many of us hesitate a little bit about how to approach the national prosecutions there. Institutional capacity or competence may be weak in some cases. We have resource limitations. It's obvious, but I honestly can't tell you how many new computers I've seen in rural police stations that have never been used to file a police report because the donor never sent a printer to go with it. Or even where we see a prosecutor or a police captain who's well-trained in sexual violence crimes and a victim-centered approach, it doesn't really matter, actually, if the gender norms still mean that survivors are not treated respectfully when reporting their experiences. Many just won't disclose. There are also still blind spots in terms of charging for sexual violence crimes. In some cases, we see the total failure to include those charges in initial indictments. We saw this in Senegal and also in Uganda, for example. Or we see a tendency to treat terrorism cases slowly as terrorism without addressing the underlying sexual violence that is at the heart of the mode of operation. We see very patchy witness protection and support. Sometimes it's left to the creativity of an individual judge, or is only understood as happening or relevant to what happens in the four walls of a courtroom, not a responsibility at first contact with a witness. We have challenges in delivering reparations. Even though they might be ordered, they're very, very seldom actually implemented and delivered. And then, of course, we have concerns about rights of the accused. It's not particular to conflict-related sexual violence cases, but we are concerned about violations of due process in some systems, including protracted pretrial detention or rushed mass trials. And SRSG Patton mentioned the sustainability challenge earlier as well. But in spite of all of this, I'm a bit of an optimist. I still see huge potential in national courts, particularly if we can increase the ways they can access support or exchange from international actors. Even the most insular, self-sufficient domestic courts or isolated military tribunals can explore the benefit of international partnerships or resources, at least in the beginning, as they build up expertise in some cases where it's very new. In other national systems, the expertise is already there. They've been doing this for a very long time and doing it quite well. So I think that what we should do is not think about a false dichotomy between international and national systems, but the ways that actually international actors can find and be invited into national systems to support and enhance certain aspects of the work. There's plenty of expertise to go around, and none of us has the monopoly on it. So I really look forward to this conversation, and thank you so much for having me.
Thanks a lot, Kim. I think some of the points you made can resonate with many of us, and I think it will become a quote that we will use: your many routes to accountability. I'd like to point to a number of the points you've made, which I think come through the special issues and the work of a number of the authors in the special issue, and that's the idea of having domestic accountability processes playing a transformative role, especially in conflict and post-conflict moments. And the two things you point out, I think, are critical, which is transforming a post-conflict setting into a culture of trust in the institution, and transforming the institution themselves through building them by doing. I think these are things that are absolutely critical and that have proven, as we see in the various work as part of the special issue, to be key for accountability, but also for sustainable peace. Obviously, as you pointed out, there are quite a number of challenges remaining, and we need to all be part of supporting those efforts. And your point on the false dichotomy between domestic or international, I think, is something that we all need to reflect on, especially at a moment where multilateral action is being called into question, and how that might impact on accountability. One important aspect of national accountability efforts that came up in a number of articles, including in your piece, Kim, is the need and the importance for partnerships and sharing expertise about investigations and the handling of victims and witnesses. Our next panelists are Karen Neymar and Daniele Perisi. In addition to being the contributors to the special issue, Karen Neymar is the Director of Programs for Physicians for Human Rights, and Daniele Perisi is the head of the Great Lakes Program for Trial International. Daniele and Karen, your articles discuss the importance of multidisciplinary cooperation in national accountability efforts. In the DRC, Trial and PHR partnered together on the Kavumu case. Other international actors like the UN team of experts and the UN missions were also involved in supporting the effort. Could you maybe discuss with us and enlighten us a little bit about what innovative approaches did PHR and Trial International, as well as their partners, use to support national judicial authorities in this case, particularly regarding the development of a strong medico-legal cooperation?
Thank you. It's a privilege to participate in the dialogue today. The special issue highlights the emergence of a quiet revolution where national courts are taking the lead in adjudicating cases of conflict-related sexual violence and serving as a crucial venue for accountability and access to justice for survivors. This is propelled by courageous clinicians, police officers, lawyers, and judges who assume significant risk by pursuing these cases in their own communities, and by strategic partners like the SRSG and the UN team of experts who provide technical expertise and a key political platform to support this work. The landmark Kivumu case in DRC illustrates this point. In 2013, clinicians at Panzi Hospital in South Kivu started to see cases of young girls between the ages of 18 months and 11 years from the nearby town of Kivumu, presenting with the same story. Each time, the child was abducted from her home in the middle of the night, taken to a nearby field, brutally raped, and then abandoned. The injuries sustained were similar too, and the severity shocked even the most experienced clinicians. Over 3 years, more than 42 young girls from Kivumu arrived at Panzi Hospital, where clinicians trained by Physicians for Human Rights documented the forensic medical evidence in each case. The community in Kivumu was so terrorized by these attacks that activists from the town joined together with clinicians, police officers, and NGOs to mobilize a task force for justice to support investigations. But the local civilian magistrate refused to launch one because, as we learned later, a powerful sitting member of provincial parliament and the militia he controlled were suspected of carrying out the crimes. While the investigation stalled, Physicians for Human Rights collaborated with the task force and Dr. Denis Mukwege, founder and medical director of Panzi Hospital, to bring international attention to these cases and to pressure the Congolese government to act. We also partnered with the SRSG and the UN team of experts who amplified the call for accountability and urged national authorities to prioritize the prosecution of these cases. And we joined forces with Trial International, a Swiss-based NGO, which joined the task force and helped to support the Congolese legal team representing the victims in the case. Because of this serial and systematic pattern of the attacks, military authorities took the creative step of aggregating the cases and framed them as a single case of crimes against humanity. This innovative legal theory allowed military justice to assume jurisdiction over the matter in 2016, which infused a new energy into the investigation. Within months, Congolese officials arrested dozens of militia members, including the powerful sitting member of parliament, Frederick Batumike. Immediately after the arrest, the crime stopped. The case was complicated though. Not only did Batumike instill enormous fear in the community, he also enjoyed immunity because of his status as a sitting lawmaker. The task force worked with national authorities to remove Batumike's immunity so he could stand trial. And by September 2017, the military prosecutor indicted 18 defendants for acts of rape constituting crimes against humanity. After a 5-week trial in December 2017, a mobile military court convicted 11 men, including Batumike, of crimes against humanity for the systematic rape of dozens of girls and sentenced the defendants to life in prison. They swiftly appealed, but in 2018, the High Military Court confirmed this landmark decision. The judgment marked the first successful conviction of sexual violence as a crime against humanity in the DRC for a sitting lawmaker and for serial crimes. And it marked the culmination of 5 years of groundbreaking work, especially by Congolese medical and legal professionals who led this effort and were powerful agents of change in their own communities. I want to highlight 3 important lessons learned. First, the coordination between national and international partners was a fundamental feature of the case. Dealing with complex mass crimes requires a combination of expertise, including criminal investigation and prosecution strategy, collection of evidence, legal analysis, use of forensic medical tools, security, logistic support, and advocacy. To achieve this, coordinated action is key. The Justice Task Force, comprised of grassroots activists and professionals and international partners, embodies that collaboration. Second, the case confirmed the power of medical legal collaboration, especially for gathering comprehensive forensic evidence and for victim and witness protection. As the prospect of a trial loomed, the idea of the young survivors appearing as witnesses in court became deeply concerning. So investigators and prosecutors worked with the clinicians, the survivors, and their families to pursue a trauma-informed strategy. The judges allowed the child survivors to be interviewed and recorded by forensic clinicians with informed consent. During the trial, the court referred to the recordings in lieu of compelling the survivors to appear as witnesses. This approach was unprecedented in DRC and spared the children from being intimidated by the militia members sitting in the dock and the hundreds of spectators watching in the public gallery. And third, for sustainability and scale, it's critical to invest in the capacity development and mentoring of national medical, law enforcement, and legal professionals on gathering forensic evidence, investigating and prosecuting mass crimes. These professionals are agents of meaningful and sustainable change in their communities, making it harder for judges to deny or dismiss evidence of criminal liability, even for powerful actors. The lessons of the Kavumu case are already having an impact, and the innovative approaches are now being replicated in other cases in DRC. With national and international coordination, medical legal collaboration, and investment in local justice processes and people, more survivors will obtain their day in court, and those who perpetrate these crimes will be held to account in their own communities.
Thank you. Thank you, Karen. We have an issue with the... Thank you, Karen. Thank you, Karen, for this extremely interesting account of the Kavumu trial. I think all of those of us who worked in the Congo remember where we were when those trials were conducted, and certainly distinctly felt that there was a message of hope for all of us and the victims when this came through. I think what you gave us here was also an excellent lessons of what it means to work as one and leveraging all of everyone's expertise, and also questioning status quo. I think the legal innovation you mentioned are absolutely case in point, and a number of things that we need to learn from. What I find interesting in this case is also that there's a lot of lessons that can be learned, but have not necessarily been learned and replicated elsewhere. They certainly have served well the advancement in the Congo itself. But in fact, these are areas where we could use and leverage some of the strategies and tactics and modus operandis and partnerships that were leveraged in the Congo and have not yet been leveraged in other contexts. We'll turn now to Daniele for a second part on the Kavumu trial. Daniele, the floor is yours.
Thanks a lot. Thanks, Chloe. Indeed, as Karen was mentioning, the hurdles that we faced throughout the years of investigation and prosecution of the Kavumu case were very numerous. I just wanted to highlight one of the main hurdles that we faced during the time we worked, and that issue was the issue of domestic communities. Because as you understood from Karen, the theory of the case was that the militia committing the crimes was organized and directed by a provincial lawmaker. Not only was he the most important public figure in the area, enjoying de facto protection from local authorities, but he also enjoyed legal immunities from prosecution according to the Congolese constitution. And we all knew how difficult it is to overcome this legal barrier. Even looking at precedents in state practice from other countries, there wasn't much. Maybe you are familiar with the Rios Montt judicial saga in Guatemalan courts. Even there, the former head of state was prosecuted eventually by domestic courts, but only after the end of his term in parliament because of his domestic immunities. So the legal strategy that we devised revolved around the use of the Rome Statute of the International Criminal Court as a tool to push forward accountability at the domestic level. And it's interesting, as Kim noticed, to note here the articulation between the two levels, the international, the Rome Statute level, and the domestic law level. So the Congolese constitution stipulates, as many constitutions do, that duly concluded international treaties have an authority superior to that of domestic legislation. Plus, thanks to persistent advocacy throughout the years by human rights groups and civil society, the DRC had, in 2016, introduced the Rome Statute into its national legislation. And the relevant national statute explicitly includes the text of Article 27 of the Rome Statute. Now, Article 27 is the article that affirms the principle of irrelevance of official capacity, meaning that basically, as far as international crimes are concerned, the law shall apply equally to everyone without any distinction based on official capacity. Therefore, our argument went as follows. If it's true that sitting parliamentarians enjoy immunity from prosecution according to the Constitution, the principle of irrelevance of official capacity in cases of international crimes, as contained in the Rome Statute, but as also integrated into domestic law, has to prevail over the constitutional immunity provision. And this is consistent with the drafting history of the Rome Statute, showing that this article was intended to have effect not only before the ICC, but also in national proceedings for atrocity crimes. So this is in a nutshell the argument, the legal argument that won the day in the Kavumu case, and thus prosecution was possible. So in conclusion, I just wanted to share a couple, I think, of lessons to be learned and strategies that can be applied also in other contexts. In particular, first of all, for activists, but also for policymakers, the importance of using the Rome Statute and the importance of how the Rome Statute and in particular its immunity rules are implemented into national legislation so as to render domestic immunities irrelevant for international crimes. Secondly, for researchers and for the legal community at large, the need to deepen the understanding of the interplay between the Rome Statute and domestic immunities for international crimes. I think that the Kavumu decision shed some light on this issue, but further research and further application, hopefully in other jurisdictions, would certainly be helpful to better delineate the contours and the scope of this principle. Thanks.
Thank you very much, Daniele. The way in which the Kavumu case took on the issue of impunity was indeed remarkable, a remarkable development, and so crucial for addressing impunity at the national levels, where immunities are so often an obstacle for achieving justice for victims. And it will certainly be important to implement these strategies, as you mentioned, in the future. Thank you, Kim, Karen, and Daniele, for your insights thus far. And we're going to now turn to some of the questions that our participants have submitted for all of the panelists to reflect on. We have about 20 minutes of question and answer. And the first question, which comes from one of our participants, is to Daniele. In the Kavumu case, the defendant, which is a member of parliament, was condemned for paying reparations to the victims. However, more recently, in the Kokodikoko case, the Congolese state was itself called to pay reparation for the crimes of sexual violence committed by a non-state armed groups. Why do you think it is important for states to be accountable for reparations when such crimes were actually committed by non-state actors?
Thanks a lot. That's a very interesting question. A central part is true. The central part of our work on these cases has been on reparation, on the issue of reparations, and this issue is a complex and multifaceted one. Maybe a couple of points here from my side. So first of all, one aspect is related to financial reparations, what we also call compensation. So normally, individuals who have been found criminally guilty have to pay compensation to victims. For international crimes, it is often the case that on top of the responsibility of the individuals, there's also an element of civil liability of the state, either because the individuals committing the crimes were state officials or because the state did not do enough to protect its citizens from the crimes. So now it's sometimes really crucial that the state is found civilly liable jointly with the individual perpetrators, of course, because then the state is also responsible to pay the compensation awarded to victims. Not only does this better capture the systematic nature of these crimes, but it can also make the difference concretely for the victims. When the individual perpetrators don't have the financial means to pay compensation, or where the national system is not well equipped to track and freeze assets in order to pay compensation. So in the Kavumu case, unfortunately, the military courts dismissed our claim to recognize the state as jointly liable for the crimes. So the state is not responsible to pay compensation. And that means that up to this day, we're still fighting in the Congolese courts in order to have the assets of the convicted parliamentarian located and seized for victims to receive the awarded compensation. More recently, the other case you mentioned, 2019 Coco di Coco case, we were successful in claiming the responsibility of the state for sexual violence crimes committed by an armed group, because it was established that the state didn't take the necessary measures to protect the population living in the area. And so therefore, the state is obliged to pay compensation together with Coco di Coco, the militia head, and its militia members. And I just wanted to briefly touch upon a second point that represents, I think, reparations-wise, an important legal innovation of the more recent Coco di Coco case. It concerns the variety of forms of reparation. Because according to international law, victims of international crimes should have access to full reparation, entailing different forms of reparation. Unfortunately, at least in DRC, up until a few months ago, the judicial system recognized only financial compensation as the only form of reparation. But in the Coco di Coco case, we obtained for the first time in DRC the acknowledgement that victims of sexual violence crime have the right to be awarded not only financial compensation, but also rehabilitation, that is free access to medical and psychological care. So I think that this represents a key precedent insofar as it speaks to the needs of many victims of sexual violence and provides an additional avenue for justice and redress.
Thank you very much, Daniele. I think this was also quite an innovative and groundbreaking moment in terms of legal advances and victims' rights implementation. And I'd like to draw a parallel here in terms of how important what you said is. As I'm sure many of you know, at the political level, protection of civilians in the context of conflict is something that is the primary responsibility of states. It's something that's well recognized as a political tenet. So it does kind of link to your point about, making the state responsible also for protecting its people, even when they're not the direct perpetrator of the violence. Thank you for that. We'll now take a second question, which is directed to Karen and Guido, and then I'll turn to the SRSG. How can international institutions work better with national actors when the latter are reluctant to investigate? What interventions can be made at the technical and political level? Maybe we can start with you, Karen, and then go to Guido and then go to the SRSG.
Thank you for that really important question. It's our experience that domestic prosecutions really live or die on the political will of national actors. If political or judicial authorities are unwilling to pursue a case for political reasons or other reasons, then there may be an opportunity for international institutions to either engage in quiet diplomacy to encourage domestic government action, or to use public platforms to pressure governments and invite international media attention and scrutiny when all else fails. And frankly, we used both of these tactics in the Kavumu case early on. But if national authorities have political will and lack the technical capacity or resources to support a judicial process, then here there's considerable opportunity for international partners to provide technical support through training and mentoring, through support with security and logistics, and also some really interesting, innovative legal thinking. When national authorities are open to partnership, there's a great possibility for learning and exchange in all directions, as Kim mentioned earlier. That openness on the part of Congolese stakeholders and military justice was a defining aspect of the Kavumu case. Congolese authorities were open to forging alliances across sectors, taking a survivor-centered, trauma-informed approach to evidence gathering, and they embraced the fact that they were effectively pioneering innovative tools domestically. For international actors, it's critical to approach collaboration with national authorities with enormous humility. That has to be the foundation for any partnership or technical or political intervention. Here too, as Kim mentioned, there's enormous expertise and knowledge and context at the local level that has to inform any partnership or collaboration. And as international partners engaged in the Kavumu case, it was always clear that Congolese professionals were firmly in the lead, and that the survivors and their families were always at the center of the justice process. That shared mission really helped to reinforce our approach and helped all the partners focus on really just getting the job done. Thanks.
Thank you. Thank you. I think everything has been said. Just a very, very short reflection, if I may. As mentioned already, we definitely need, in my view, a tailored approach to a specific country and help in sharing the experiences from other systems. This means, in a sense, fostering the cross-contamination of approaches, and which may end up sharing good practices and novel ideas among different legal systems. Such ideas and innovative approaches, we heard some powerful examples just now. They need, of course, to be tailored, and this must be done by a proactive and dynamic local actor. We have realized in this type of work, I think, that a network of local invested actors is indeed crucial, and it can be through lawyers representing victims, it can be prosecutors, civil society organizations, or a combination of these. A national prosecutor, for example, may have found a new way, an innovative way to assert jurisdiction in case of a human trafficking offense. Or another may have demonstrated how to harness the power of victims participating in the proceedings. An NGO in a third country may have proven experience in dealing with psychological trauma of sexual violence and found effective ways, as it was done in the Kavumu case, to bring this to the attention of the judges, but with a careful approach. All of these experiences may and should benefit other systems in a different continent, if need be. They can do that if they are shared in a language and in a way that is understandable and tailored to another legal system and another culture. So this is a big type of work that can be done by the team of experts, even by academic publications such as the Journal of International Criminal Justice, in a sense, and through different ways through which the international level can really assist in disseminating and cross-contaminating innovative approaches and ideas. Thank you.
Thank you, Guido, and we'll turn now to SRSG Patton.
Well, thank you, Chloe. I endorse everything that has been said by the two other panelists. Indeed, national actors may be reluctant to investigate for two key reasons. Either they may be genuinely unable to investigate due to lack of capacity, resources, or they may be unwilling to do so due to political interest or priorities. And the point you've made about pressure is really an important one. And it reminds me of two concrete instances, examples that I'd like to share. For example, I had to go on mission to Guinea-Conakry to meet with President Condé to raise the question of the trials after the closure of the investigation phase, etc. And that turned out to be a very difficult meeting. And it was clear that there was no political will. He took a few steps after that meeting with him by establishing the steering committee. But that meeting was in 2019, and we are still not there yet. The steering committee is doing its work in ensuring that the trials do take place. There was also the Terrain Hotel case that you will all recall. I had the opportunity of going to South Sudan at the time when the judgment, according to information I had received, was lying on the desk or in the drawer of the president. And it so turned out that I was in that meeting with the Deputy Secretary General, and we both raised the Terrain Hotel case and the long-awaited judgment. And we bluntly told the president that we knew that from the judges that the judgment was ready and was sitting on his desk. And soon after we left, the judgment was actually released. So if there is political will, engagement is easier because then with relevant capacity support, justice is definitely achievable once you create the conditions for it to occur. And this is precisely the kind of support that the team of experts provide to member states, strengthening judicial mechanisms for prosecuting perpetrators, training of judges, prosecutors, and police to gather evidence and prosecute crimes effectively without shaming and re-traumatizing victims. But often the situation is not so clear-cut, and there is a combination of both lack of capacity and lack of political will to investigate and bring perpetrators to justice. And in such a situation, beyond technical support, what my office also seeks to do is to rely on the political commitments with national government on issues of justice and accountability, or seeking to secure new political commitments. And for example, if you go through the joint communique signed between the UN and the governments of Central African Republic, DRC, Iraq, Mali, Myanmar, or Somalia, you will see that both parties make very specific commitments regarding the promotion of accountability for serious crimes. And these joint communique represent very important advocacy tool, not only for my office, but also for other UN agencies and anyone seeking a concrete benchmark to hold the government accountable. And it varies from country. For example, Myanmar is a country that has taken a specific commitment when it comes to accountability, where implementation is very slow, and it has been very difficult to engage with Myanmar as opposed to the other priority countries. And one last point that I want to make is that we also must not forget the role that local practitioners can play. They work with survivors of CRSV and they can play a vital role in promoting accountability at the domestic level. And with appropriate training and resources, they can contribute significantly. And there are many instances where I have seen this firsthand, where they can contribute to the documentation and prosecution of sexual violence cases. Thank you.
Thank you very much, SRSG, and to all of you. I think the conversation today really shows that beyond a very narrow understanding of accountability and legal approaches to accountability, there's really a holistic approach to accountability, which includes various levels of expertise, but which also requires contextualization and intent, which means political strategies for accountability and for pursuing accountability. I think it's quite heartening to also hear all the progress and all the efforts that were done in the context of the Congo, and how local and domestic processes have actually been able to do, in some instances, more than international processes might. With that, I'm turning to yet another question from our partners, and the question is to Kim. Kim, your article mentions that the Special Criminal Court established in the Central African Republic to respond to serious crimes committed during the conflict as a special investigation unit. At the same time, the Central African authorities also established a special police unit to respond to sexual violence and crime against children. What are the benefits or the challenges of having such specialized unit? And what do you think should be taken into account when creating such units in terms of expertise, training, structure, mandates, or operational challenges? Over to you, Kim.
Thanks, Chloe. You know, I actually had the great opportunity to work with a team of experts in the Central African Republic years ago. I landed at the airport in Bangui during a blackout, and I must tell you, I was never more grateful than then that Sophia Candeas from your team was on my flight, because I didn't know where I was going to go at all, so particularly in the dark. So thanks for that, Sophia. You know, in CAR, I think the team of experts was actually one of the first actors to acknowledge the fact that in such a difficult context, it's important to be very efficient with limited and existing resources. So as you mentioned, Chloe, we had a special criminal court with its team of investigators who'd be trained on international crimes generally, and then on the other hand, in the national police or national law enforcement system, we also had UMIR. It's a rapid response unit that was consisted of police and gendarmes who were focused on violence against women and children generally, not particularly international crimes. And so we had two different teams that still had potentially overlapping mandates. So the team of experts brought the two special investigation units together, along with various UN entities and international experts, to support the national judicial authorities in operationalizing and coordinating these special units so they would work with and not against or in spite of each other. And so not just in CAR, but I've given specialized units a lot of fodder over the years. I've seen them crop up in many different jurisdictions. And I think on the whole, it's a very good thing. I mean, it's incredibly important, as you say, to have specialized expertise built into law enforcement and judicial systems, because we need officers and prosecutors and judges who understand the specific complexities of barriers to disclosure of sexual violence, for example, or how to deal with trauma and then have a survivor-centered interview, for example, or the intricacies of evidence collection that Karen and Daniele were mentioning in their work in Eastern DRC. Specialized units are very important and can be one way to build this and bake this expertise into a system. It's also important to build gender balance onto these teams and provide ongoing training and potentially mentorship, not just at the initial orientation or onboarding. But I do have some concerns, you know, as I do with everything. And I think that we have to be careful of siloing that expertise. We need it, but we can't contain it too tightly. My two concerns are this. Number one, I worry that the presence of specialized units, whether it be prosecution or police units, for example, can sometimes lead to an abdication of responsibility on behalf of the greater police force or other prosecutors in the office. I've seen indication here and there that sometimes regular, quote unquote, regular officers and prosecutors may not feel responsible for dealing with sexual violence or national crimes case when there is a special unit to deal with those cases. And so when those cases come across their desk or when they're working in a rural area where the specialists aren't available, they either don't know what to do or they just don't feel that it's their responsibility to take the first step. And so I worry about that as a potential unintended consequence. The second thing I worry about is coordination. It's great to build specialized units, and I've seen in some countries that there may be a specialized unit focused on sexual and gender-based crimes, and then down the hallway or even in another building, there's a specialized unit focused on international crimes. And like what we saw in CAR, it's really important that they be talking to each other, they be cross-trained, they coordinate with each other. Otherwise, where you have a complex and multifaceted crime like conflict-related sexual violence, what's going to happen? Those survivors may fall through the cracks for the same concern I just raised. The sexual violence team may not have the expertise in the international crimes aspects of it and may not activate. Or alternately, the international crimes focused team may not be really sensitized or specifically focused on the gendered aspects or the sexual violence complexities of those files in front of them. So we need very clear standard operating procedures for things like file sharing, for collaboration, for co-interviewing, all of these things that will make a more streamlined and enriched process that, by the way, will make it easier for survivors and witnesses. They don't have to be re-interviewed. They don't have to be run in circles among different actors on a team. So I do think that that is something I worry about when we talk about specialization. And I'll stop there in the interest of time, but I'm happy to talk about specialized units all day long, if you like.
I'm sure we'll have other opportunities, Kim. Thanks for that. We'll take a last question from a law school student, and I'll address it to the SRSG, Patton. The special issue talked about the progress made in the field of domestic accountability for serious crimes of sexual violence. However, in the last years, we have been confronted with such brutal crimes performed by terrorist groups like ISIS or Boko Haram. We also know that neither national courts nor the ICC have prosecuted a single case of sexual violence committed by these groups. What do you think can be done at the political level to make any real progress in such context? SRSG Patton, the floor is yours.
Thank you. This is an interesting but very, very difficult question. In fact, I'm disheartened to see how, when addressing crimes committed by terrorist groups, whether in Nigeria or in Iraq, that national judicial authorities continue to rely on anti-terrorism legislation that allows for easy charges, focusing on affiliation and membership, and not requiring or demanding evidence about additional criminal conduct. And I still recall vividly my meeting with the High Judicial Council in Iraq, and I had a meeting with the Chief Justice, and I was trying to impress on him that if sexual violence offenses are not prosecuted per se, there may be no historical record of the atrocities committed by Daesh on women, especially the Yazidi women and girls. And I was trying to highlight to him the importance for women to have their day in court. But he simply didn't get it. And for him, his argument was that with prosecution under the anti-terrorism law of 2015 in Iraq, it was an open shut case, proving affiliation, and that's the end of the matter. And unfortunately, we have not seen much progress in Iraq, despite the expression of political will by the government to ensure accountability. For example, while manifestations of sexual violence, acts of sexual violence are traditionally criminalized in general criminal codes, including that of Iraq or Nigeria, they are not criminalized as acts of terrorism under current anti-terrorism law. And consequently, prosecutors do not consider sexual violence when analyzing the crime base or preparing their case files in the context of terrorism. And another drawback which I've noted is that the investigation and prosecution of crimes of sexual violence in the general criminal code is almost always conditioned on the complaint of a victim and not the prosecutor's proprio motu powers. And that was an argument that was actually raised in Iraq. I must say, and you may well recall that in March 2020, the media reported the first judicial case where sexual violence committed by ISIS was acknowledged with the perpetrator convicted to death sentence before a criminal court in Baghdad. And I was elated, but upon verification, it soon transpired that this information was not accurate at all. And what is more disturbing is that it turned out that although the court heard the victim's testimony about the acts she endured, from her capture to her sale multiple times and her sexual enslavement by the defendant, the testimony was not in itself an element of any of the criminal offenses contained in the charges against the defendant, which was violence or threats, which aimed to bring about fear among people and participation in armed terrorist gangs. So the defendant was charged and convicted solely under the anti-terrorism law of 2005. So moving forward, I think it is imperative that we continue to impress on member states the importance of crimes of sexual violence being prosecuted as an existing offense under general criminal law, whether it is rape or trafficking. We also have to pursue efforts to support member states in bringing necessary legislative reform, because it is important for national legislators and policymakers to ensure legal reform that would enable the full range of sexual violence offenses, from rape to sexual slavery and forced prostitution, forced pregnancy, etc., to be covered in their national penal laws. And in this regard, I must say that my office launched on the last October, on the occasion of the commemoration of the 10th anniversary of the mandate, a legislative guidance for the benefit of member states. And the legislative guidance is currently going through an internal UN process. And hopefully it will be available to assist all member states. And that's an essential element in the legislative guidance. But of course, for any of these things to happen, we need the commitment of relevant member states to acknowledge the problem and to work together on identifying and implementing a solution that would allow us to bring justice to victims of sexual violence committed by terrorist organizations. I'm also working with the Office of Counterterrorism in trying to get their support, and hopefully we'll make some progress. But it would be important to have an open discussion and reflect with member states, national judicial institutions, and victims association on how we can address these problems and to develop a victim-centered rather than perpetrator-driven approach to justice. Thank you, Chloe.
Thank you very much, SRSG. That concludes our question and answer session. And before I give the floor to Margot Wallström in closing, I think what we have heard today makes it obvious that often we think of international jurisdiction as the only place or the main place or the primary place for accountability for sexual violence and conflict. Whereas they might have established the foundations for what was needed to bring forward those crimes to the fore. I think what we have heard today from our panelists is that domestic jurisdiction have a critical role and are currently playing a critical role. They've proven to be bold, innovative, and pioneer in furthering accountability for sexual violence and conflict. What's important also, I think, to reflect on for all of us from all walks of life who want to make a difference is that all such efforts will require investments. Investments on our part in terms of partnerships, investment in terms of expertise, and investment in terms of political strategies. With that, I am honored to give the floor to Margot Wallström to close this webinar today. Margot Wallström is the former Minister for Foreign Affairs for Sweden. It was also the first Under-Secretary General and Special Representative of the Secretary General on Sexual Violence and Conflict at the United Nations. Margot, given your experience, it would be an honor for us to hear your impressions about the current state of affairs and have a word of wisdom in terms of future challenge with regards to national accountability for conflict-related sexual violence. Over to you, Margot.
Thank you very much. Thank you for inviting me. And of course, I would like to start by showering you in thanks and praise. And first of all, to SRSG Pramila Patton and her team for their tireless work against sexual violence in war and conflict. I would also like to mention and thank Innocent Sainda Balemba, because he was the first head of the team of legal experts and set this whole thing going. And of course to Chloe, to you, because as a current team of experts leader and all of your teams, we owe you big thanks for everything you do. Thank you to all the participants and viewers of this webinar, also for being with us, but also to the Journal of International Criminal Justice for the special issue on sexual violence in conflict, and all of those contributing to these great articles, also to read for a non-legal person, non-lawyer as myself. And these articles have taken us from Colombia to Sudan to Bosnia-Herzegovina and elsewhere on a search for justice. And they have provided a lot of interesting reading. And also to all those behind this series of the Digital Dialogue series and Washington University in St. Louis as well. But first and foremost, thanks and praise to all of those courageous victims and survivors of sexual violence in war and conflict and post-conflict, to civil society, to police, prosecutors, and all those involved in the legal processes. And as has been already said, this is not an easy thing to get engaged in these processes. When I was appointed SRSG 10 years ago, we, together with my team, we soon identified some major issues to deal with. First of all, of course, how to end impunity for these crimes. Then how to prevent sexual violence in war and conflict. And also how to change the misconception of this as a lesser crime. And I think this is still something we have to deal with. And finally also, how to measure success. Because as everybody can figure out, these questions are interconnected, and ironically also, in the end, success could be measured as an increase in the number of cases reported, because finally somebody would trust the legal system to actually provide them with justice or make it worth the effort or the problems of reporting their cases. And there was, I remember also, we discussed and called it the paradoxes of action, that with awareness raising, training, court cases, you would have also a higher number of cases, and it would look as if we are not succeeding at all. Or with a very ambitious and detailed legislation, women could also sometimes be discouraged from filing a case. Now, still, sexual violence is omnipotent and a remnant of war in so many countries around the world. There were other issues that we quickly realized also would become increasingly important, like children born out of rape, like men and boys being victims of sexual violence in conflict, because that was not at that time really in the focus of attention. The whole issue of reparations, making reparations available, and so on. The team of legal experts, of course, became an indispensable tool for the mandate. And when I look back at the start of their work, it is so impressive to see what has been achieved. And if we just take the example, as has been already mentioned here, Guinea-Conakry, where, of course, the start of a legal process was to shine a light on and acknowledge historical events with the political background and to listen to survivors, and also accept that sort of, if we call them outsiders, came in to help. And it was politically, and still is, as we've heard, very politically sensitive. After a decade, the team of experts remains the only Security Council mandated entity that provides dedicated advice and capacity support to national authorities to combat impunity for sexual violence on a global basis. We have to remember that. One conclusion in the journal's special issue is, and we've heard that also repeatedly throughout this webinar, is the importance of relationships between international and national practices for building prosecutions of conflict-related sexual violence. So I want to underline that as well. And I was thinking that justice also, in a comprehensive sense, is not just law. It is also socio-economic rights. It is also political participation, as well as legal rights. And I think that becomes clear to any one of us who have visited some of these war zones or post-conflict situations, that there is so much more to this. But of course, the core of it is to be able to enjoy your human rights fully. I would like to turn to all of you who are participants also and listening in, because we also expect something from you. Governments, officials, leaders, donors, member states, civil society, as much as we want to thank you also for everything that you are doing and for taking an interest in this. Because the mandate has developed enormously and delivered on a number of issues. For example, as we just discussed, sexual violence as a weapon of terrorism, but also the focus that the EU Pramila pattern has put on deterrence and prevention, as well as looking into and describing the situation for children in armed conflict. And one issue after the other has been added to the original sort of mandate, and you've done that in an excellent way, not to mention the kind of agreements that you make now and that allows for a follow-up and implementation. The team of experts has also been relying exclusively on voluntary contributions of member states to fulfill its mandate. Let us remind everybody about that as well. So to all of you listening in and wanting to contribute, learn more about this issue. Make sure that you have all the facts, build expertise, speak well about the mandate and this task at all levels, and look at the results and try to measure results and provide more funding. So you also have to make sure that you become generous donors, because without that, we could not continue this very important work. And again, let me say thank you. It has been so interesting to come back to this whole issue. And maybe just as an anecdote, and to finish with that, and I read from my diary from 10 years back, and I won't say which country. This is from a visit to that particular country, and we were able to meet with the Prime Minister. And I wrote also that the Prime Minister was very self-confident, and his posture, I wrote, can be summoned the pride of sovereignty without capacity. The preceding meetings with ministers were testing, at least the one with the Deputy Prime Minister, who clearly detests me, I wrote in an extra sentence. And we were then lectured by the Minister of Justice, who in the end realized that a person who was with us was his best friend to get things done and money. And the Minister of Foreign Affairs gave his verdict. We have studied your speeches to the Security Council in detail and found them fair. So sometimes they also realize the role of the Security Council, of the team of experts, and of course the SRSG, who needs to be able to carry out her and the team's important work. So thank you for providing us with an amazing webinar. Thank you for having me as well.
Thank you, Margot. Thank you for those very personal reflection and those inspiring words that call on all of us. With that, I'd like to thank all of our panelists and speakers for joining us today and for their insights, and all of our viewers for joining as well and sending in questions. A big thank you also to Kim and the Washington University of St. Louis for hosting this session. It's been a great first session of our Digital Dialogue series. I would also like to pay particular tribute to Karo Okwuzumi, without which the special issue of the journal would probably not have seen the light of day. So in my seat prior, and certainly we're indebted. This has been a great first session, and we will be continuing this series of webinar over the next months. The next session will be in September, and it will address national prosecution of conflict-related sexual violence in Guatemala and Colombia. So stay tuned for more information about that event. And we will be hosting webinar sessions about justice for CRSV cases committed in terrorist context, accountability in Central African Republic, prosecution of slavery in the 21st century, reparations for victims of CRSV, and gender-based and masculinity in response to CRSV. These are all issues that have been discussed in the articles of the journal. So once again, I encourage you to go and read, learn, as Margot admonished us to do. Thank you again to the SRSG, to Ms. Wallström. Thank you to our excellent panelists and to the audience for attending this digital dialogue. Have a great rest of your day, and we hope you join us for all of our future sessions.